Good morning, everyone. Welcome to another Bloomberg Opinion live stream. I'm Tim O'Brien. I'm the Senior Executive Editor of Bloomberg Opinion, and I'm joined today by my friend, colleague, and typically wise man, Noah Feldman. Noah is a law professor at Harvard Law School. He and I have done these before, and we're convening today because, of course, there's been a string of monumental Supreme Court rulings lately, including a ruling yesterday on presidential immunity that is sweeping and will undoubtedly be controversial, but in the near term, it's going to, I think, empower presidents to act in ways maybe they couldn't have in the past, including Donald Trump, should he become president again. So Noah, I want to just kick us off with a little love letter that you can accept or not accept, but it's a short one, and it goes, "Dear POTUS, go ahead and commit a crime. Love, SCOTUS." Am I being a little bit too flip there?
It's not if you're going to have to categorize yesterday's decision in a poetic way, that's actually a pretty good way of doing it. I don't think the people who, in your theory, sent the love letter meant it to say exactly that, but I think that the reader of the letter could well read it in exactly that way, especially if that reader's name was Donald J. Trump.
You wrote in an excellent column that I recommend to everyone today on Bloomberg Opinion. In a sweeping decision that constitutionalizes the modern reality of the imperial presidency, the US Supreme Court has established near total criminal immunity for Donald Trump's official acts while he was president. It's an outcome that would have astonished the nation's founders, who feared precisely that if the chief executive amassed too much power, the republic would turn into an empire. You know, there's lots of things, to unpack in that very meaty paragraph, Noah. Let's begin with this idea of monarchical powers and the framers being completely distraught at a ruling like this.
The framers had two monarchies in their minds at all times. The first was the British monarchy, which they had just made a revolution against. And, they had different opinions about how strong the executive should be, with some people like Alexander Hamilton, as everyone who's seen the musical knows, way out on the more power side, and people like James Madison on the less power side. But they all agreed that the president was not the king of Great Britain. And one of the key ways in which he wasn't, and I'm not making this up, Alexander Hamilton actually said this in Federalist 69, was, unlike the king, the president can be impeached, removed from office, and criminally prosecuted. Right? And criminally prosecuted. So even Hamilton, who was one of the strongest pro-executive power people, still thought the president could be criminally prosecuted, which is a really nice piece of evidence to show you that the framers were not anticipating the kinds of immunities that we've seen. And then the other king that they had in mind, just to finish the thought, was the Roman emperors, specifically Julius Caesar and the emperors who followed him. Because to them, to the framers, and okay, you can say they were men, they thought about the Roman Empire every day, but they did think about the Roman Empire every day. And in their minds, what they feared was that a republic, which is what they were creating, like the old Roman Republic, would devolve into an empire. And that is, in some sense, what has happened over the last, 75 or 100 years. And it's reflected in this opinion.
Let's remind our audience just quickly of how we got here. This case came before the Supreme Court. It's a Justice Department prosecution of Trump and his co-conspirators for actions they took before, during, and after the January 6, 2021 siege at the US Capitol. And in the indictment of Trump and his co-conspirators, they weren't charged with insurrection, but they were charged with various efforts to overturn the results of the 2020 election, disenfranchise American voters, and essentially commit various acts of electoral fraud. A district court judge is handling that case. Trump's attorneys appealed the ruling. And an appellate court essentially upheld the federal government's right to prosecute Trump for crimes. It went to the Supreme Court. The Supreme Court decided to take the case. I think you and I had a disagreement at that time. I thought strategically, in the interest of holding Trump accountable, the Supreme Court should have not taken up the case. You, with much more learned and observant abilities than I, said it was important that the court take it up because this issue of immunity was so monumental and fundamental that the court needed to put some parameters around it. Now here we are, and I think what they've essentially said is that the ruling may allow and even encourage presidents to commit crimes if they're acting under the boundaries of constitutional authority. And in the court ruling, they offered some, I think, precise definitions of what that constitutional authority is, simply delineating what exists in the Constitution itself, but also talked about things like the outer limits of that authority in much more nebulous ways. And we'll get into that more, but I wanted just to ask you first, were you surprised by the ruling, Noah?
It went much further than I anticipated that it would go. I thought that some of the more conservative justices, like Justice Thomas, would have had something like an absolute immunity idea because of Thomas's views that the executive should basically be able to do whatever he wants. But I didn't think that the more centrist conservatives would go quite as far as they in fact did. And so that was a really noteworthy result. Chief Justice.
Wait, let's stop on that point for just a sec, though. Why do you think the three centrists, Roberts, Coney Barrett, and Kavanaugh, did go further than you anticipated and joined with Alito, Thomas, and Gorsuch in this ruling?
I think that for Roberts and Kavanaugh, at least, they're both people who've worked for a president, and they have very, very strong instincts to be supportive of the executive branch in any conflict with Congress. We know that from the past. And now it turns out even their loyalty to the judiciary is weaker than their loyalty to the executive. And then I think that left Barrett, who I think was maybe tempted in this case to be a little more in the position that I think her old mentor Scalia would himself have been in, which would have not gone as far as this. And she joined a small part of the dissent and dissented from a very small part of the majority opinion, which showed that she was kind of wavering a little bit. But in the end, she stuck with the conservative team on this one for the main parts of the holding.
You just said a really amazing thing to me, which is that the centrists decided to side with the office of the president and the executive branch rather than with the law, when I would think the highest and most central calling for the court should be adherence and respect for the law itself, apart from how any office holders are intersect with it. Does
can I say something about that too?
Yeah,
I mean, it is distressing to me. So let me start by saying I am distressed by this holding, and I hope my column reflected that. I also know where it came from. And let me say one more word about what Roberts' thinking probably is. Roberts still values the judiciary over everything else, but he also thinks the judiciary needs to be, as he put it famously, an umpire calling balls and strikes. And it seems to me that he wants to avoid a situation where the courts have to weigh in on the actual conviction of a president. He doesn't want to see a former president of the United States tried criminally, unless in very, very, very rare and unusual circumstances. And so that's probably, at least in part, because he wants the courts out of that business. So by deferring to the presidency, by creating immunity, you radically reduce the likelihood of future situations or current situations where the courts have to decide whether the former president is guilty. And especially because that means if it's a former president, which it always will be just about, that person is being charged by a current president. And what are the odds that the current president is going to be of the same party as the former president who's charging them with a crime? So it can lead to the criminalization of the political process. And I think Roberts is genuinely worried about that happening. If I could say that one word in his defense, though I still fundamentally disagree with the holding.
And obviously just the politicization of federal prosecutions overall, regardless of who's in office. And that's a worthy thing to be wary of, as you note.
Especially if Donald Trump might be president again. That's a major reason to worry about it.
Correct, because in that analogy of Roberts saying that the court's only role is to be an umpire calling balls and strikes, that presumes the batter isn't cheating. And if the batter is in the box and has a weighted bat or someone telling what pitch the pitcher is going to throw, the umpire simply calling balls and strikes actually doesn't meet the moment. And that's the challenge that Donald Trump has presented, I think, to the Constitution and to democracy and to the courts ever since he entered the Oval Office in 2016 and may be well on his way to another visit. I want to read, since we're focusing on Robert, the immunity decision. The president is not above the law, but Congress may not criminalize the president's conduct in carrying out the responsibilities of the executive branch under the Constitution. That sounds fairly straightforward. And I've admired Roberts in previous rulings, including around Trump's tax returns. He has time and again noted no one is above the law. He cited the framers. He said no American is above the law, and that includes the president. But then he qualifies it here. I think this is the first time I've seen him qualify it, and this sort of umbrella, I would call it an umbrella get out of jail free card that he gives the presidency is as long as it comports with constitutionally conferred duties. But there are a lot of things presidents do in this day and age that aren't defined by the Constitution. And I feel like the court has left open this very kind of, there's this nebulous, ill-defined nature of what the president is and isn't allowed to do constitutionally that I think is going to trip up interpreters of this ruling and people who want honest presidents to be, held sacred from partisan prosecutions, but lawbreakers to be held accountable.
Look, I think you're right, Tim, that is a major likelihood as a result of this. I think there's something very confusing to the ordinary reader about what Roberts said. So let me say a word just to unpack it. What he thinks he's saying is that the president has some duties that the Constitution gives him, and Congress can't make it a crime for him to do the things that the Constitution already gives him the fundamental authority to do. Like, let's say one of the inherent powers of the presidency, we can probably agree on this, is to make foreign policy for the United States as the chief executive. Congress can't write a law saying it would be a crime, Mr. President, for you to make peace in the Middle East. We don't want you to make peace in the Middle East. It would be a crime if you did so. So that sentence seems reasonable, and that's what Roberts is wanting to say. But here's the problem. Imagine a president is exercising one of his actual powers, like foreign policy making, but he's doing it in a corrupt way. Sort of way that, at least in my opinion, a sworn testimony Donald Trump did when he made his call to Vladimir Zelensky to try to pressure Ukraine to do investigation of Joe Biden.
For which he was impeached, by the way.
For which he was impeached, though not ultimately convicted by the Senate. So in my mind, an act like that should be criminalizable. Congress should be able to say, President, you can't corruptly and in the interests of your own accomplishments do something that's nominally within your powers, but in a way that violates our laws. And that must be true, because if you think about, let's say bribery, if the president is bribed to do something and then he does that official act, he still has to be able to be, that's still criminalizable. Because even if his official act was one that he's allowed to do, like say it was a pardon, let's say someone gave the president money in exchange for a pardon. That's a crime under the standard sense of bribery law. And the court didn't say that the president couldn't be prosecuted for that, even though pardoning people would be an official act. And so what's problematic, very problematic about the ruling is that when lower courts look at it, they're going to say, well, we know that in theory it should be possible to charge a president with bribery, with accepting a bribe to perform an official act. But since that's an official act and he has presumptive immunity for it, we're not sure that we can actually allow the criminal charges to go forward against him. And then it becomes the letter that you described. Go ahead, Mr. President, commit crimes freely, and no one will be able to prosecute you. And so that really is the crux of where Roberts's formulation, which sounds on the surface somewhat reasonable, actually is not going to work out reasonably, but is going to turn into more of a blanket immunity for a president.
I just want to remind our audience watching this live stream that you can ask some questions in the comments thread, and one of our magical producers will try to pull them up, and Noah or I can offer a question or answer to any questions you might have. Noah, one of the things that leapt out to me in the language of this ruling was this concept of outer boundaries or outer limitations of presidential authority, which again, I think they offered examples to try to the court offered examples to try to elucidate its thinking, but I found the examples themselves to be muddled. And there were many in there, but one of the ones that really leapt out at me was Roberts refers to Trump's efforts to have Mike Pence, his then vice president, to not certify the results of the 2020 election. And Roberts notes that asking Pence to do that was well within acceptable boundaries of Trump's presidential acts. And it was a presidential act, not Trump acting as a private citizen. But whether or not it adhered to the core duties of the presidency or lesser duties of the presidency isn't clear. But if it adhered to his core duties, then he's not prosecutable, is my understanding of that interpretation. And if it accrued to lesser authorities under the lesser guidelines under the Constitution, Trump could be prosecuted. And I left that thinking, well, in the end, then these are very subjective delineations, that there is no clear standard they're using. I think when common sense would suggest a president encouraging a member of his cabinet to intrude upon an electoral process in at least unethical and possibly illegal way shouldn't be acceptable behavior. And I left again thinking, this is a muddle, and it's going to encourage any president who wants to push the boundaries of the law to do so. But am I making it more difficult than it is?
Well, I mean, I think my simplified account of what the court is saying about the conversation between Trump and Pence is that the court wants to say, look, there are a bunch of things that the president should be able to talk about with the vice president without it being in danger of being criminal. But there are some things, it's not just because they're talking to each other that it automatically is the case that they are within the zone of protection. And so then the lower courts should figure out what these statements were. And that part sounds relatively reasonable, but then if you go into the fine details, the Chief Justice's opinion really kind of makes a case for why conversations between Trump and Pence could well have been inside the bounds of what it's protectable for a president and a vice president to talk about. And he kind of makes the case for Trump. And then he says, or it could have been the other way. Go back to do it, lower courts. So there's a kind of message to the lower courts there, an implicit message that says, you should find that the conversations between Trump and Pence were protected within the president's duties, and therefore that you should dismiss the charges. Another way to think about this is like what the court should have said. So I think what the court should have said was, look, when the president is talking to the vice president, sure, that's perfectly legitimate ordinarily. But if the government can show in court that he was talking about doing something unlawful, namely interfering with the outcome of the election, or not even unlawful, but outside the authority of the vice president, because it's not inside the authority of the vice president to corruptly change the election results when the votes were fair, then any sense of privilege or protection or immunity disappears. That's how I think the framers would have thought of this. The framers thought that if you're performing your official duties, it doesn't matter whether you're president or the lowest tax collector, you are acting as a government official up until the moment when you're not doing it in the correct way. And the minute you're not doing it the correct way, you're outside of your powers. There's a Latin phrase for that, ultra vires, outside of your powers. And once you're outside of your powers, they would have said you can be held liable civilly or criminally. That would have been a much simpler solution And it's the one that the court refused to follow here.
But here's the rub in that explanation to me, Noah, is if the communication between the president and the vice president is privileged in the same way an attorney's confidential discussions with a client are privileged, unless it's in the service of breaking the law, in which the privilege can be broken. We have no way of knowing what the conversation is, unless to a certain extent the privilege is removed so we can get to the substance of the conversation. And then secondarily, this ruling noted that presidential actions can't be used as evidence in cases in which a president acts unlawfully. So even in the Pence example, if you violated, if you were able to pierce the veil of exclusivity and got evidence that he pressured Pence to break the law, that wouldn't be admissible in a court under the ruling that the Supreme Court issued yesterday.
Yeah, both of those things are true. So to go back to the first part of your question, how do we do it when, let's say, a lawyer is being charged with corruptly taking money from his client for some unlawful purpose, like Michael Cohen, which is literally what happened to Michael Cohen? The answer is, the lawyer comes into court and says, well, the conversations with my client are attorney-client privileged. The government then says to the court, to the judge, look, we have evidence that suggests that this was a crime. It's circumstantial because we don't have the quotes yet, but here's the reason for it. So we're going to ask you, judge, to go into a private session with no jury there, and we're going to have you hear what actually was said between the president, or in this case, the president, but it could be any lawyer and their client. And you decide, judge, were these words in fact privileged? And if it turns out, so to get that, you can't just say, the government can't just say, oh, we think there was a crime. They have to have real evidence. And if they don't have enough evidence, the judge will say, I'm not going to look at it. But the presumption of privilege is nowhere near as extensive as what the court has now given the president. That's the big difference. Right. I would have treated this pretty much the same way you would treat any situation where there's a privilege and you need to break it. And then as for the question of presenting the official act as part of evidence that the president committed a crime in an unofficial way, you're absolutely right that the majority says 5 justice to 4, that can't be admitted. And that's actually the point on which Justice Barrett left the conservative majority and went over to the liberal side, because she said, I don't see how I can prove, for example, bribery if I can't point to the official act that was done as the exchange, as the quo for the quid in the bribery situation. And that's a very powerful and correct point. And Robert sort of tried to respond to it in a footnote very unconvincingly.
We have a question from one of our viewers, and I'm going to put that at your feet, Noah. This is someone from TikTok. How is yesterday's immunity ruling any different than sovereign immunity that exists in the USA?
What's different is that sovereign immunity extends nowadays to a country. I mean, historically, a sovereign could be a king or a queen, but in the modern era, sovereign immunity extends to countries. So when we say that there's a sovereign and they can't be brought to charges in a US court, we mean that they're a government of a country. And so it's true, you can't sue, except under very limited circumstances specified by statute, a foreign government in US courts, nor can you criminally prosecute a foreign government in US courts except under rare conditions. But the president is not the sovereign. The president is the elected representative of the people. And in the United States, we, the people, are sovereign, and the US government is sovereign. So it's also true that if you want to sue the US government because you've been injured by the US government, you can't do that in a regular court. You have to do it in a special court that the US government sends you to because of sovereign immunity. But again, that's the government, which is all of us. The president is one person who is delegated by the Constitution, by us, to do a certain job. And that's exactly what the dissent is after, what Justice Sotomayor is after when she says this decision makes the president into an emperor, because an emperor was the sovereign and you couldn't sue him. That was, in fact, the very first sentence of Justinian's code of Roman law. The emperor is above the law because he's the sovereign. And we're supposed to not be that. In a republic, we're the sovereign and he's supposed to work for us. The president's supposed to work for us.
You've offered me a segue into Justice Sonia Sotomayor's dissent. I thought it was one of the, one of the more powerful dissents that attached to this ruling yesterday. And I want to read from part of her dissent and ask your thoughts on it. She says, looking beyond the fate of this particular prosecution, the long-term consequences of today's decision are stark. The court effectively creates a law-free zone around the president, upsetting the status quo that has existed since the founding. This new official acts immunity now, in quotes, lies about like a loaded weapon, close quotes, for any president that wishes to place his own interests, his own political survival, or his own financial gain above the interests of the nation. I feel like that cut to the core of this idea that whatever virtues might exist around immunity, they are only virtuous as long as the player in the White House is virtuous himself or herself. And if they aren't, all bets are off.
That's an enormous risk. And honestly, it's one of the risks of a very powerful imperial presidency. When you put that much power in one person, when that person does not care about the law, does not care about democracy, the risk to our system is vast. And in some way, you can describe, the years of Trump's presidency as various institutions. The courts, some of the time when they would strike down his actions, Congress, some of the time when it tried to impeach him, the deep state, quote unquote, that is to say the bureaucracy, some of the time when he would give orders and the bureaucrats would try not to fulfill them. All of these entities were trying in different ways. And ultimately the state governments refusing to cheat in the election. All of these are actors within the system trying to constrain one person who is trying to break the system. And what this opinion effectively says is that criminal law can't really be used after the fact of the presidency to achieve the same goals. And that's weakening of the system as a whole. The counter argument, again, just to put it on the table, would be that actually, if a president can prosecute a previous president, that's also a tool that could be very dangerous in the hands of someone like Donald Trump as president. It's another way to break the democratic system. And, in the debate, if we have to call that a debate, Donald Trump was unwilling to say that he wouldn't prosecute Joe Biden. And Trump also had the lock her up chance at Hillary Clinton, who hadn't been president, but she'd been Secretary of State. And, so I believe that prosecuting Trump was a reasonable act for the Biden folks, but I also fear the possibility of what a president who really was willing to prosecute previous members of the office, holders of the office, could do. And I think if we had Chief Justice Roberts here and he was able to speak freely, which is an impossible scenario, I think, deep in his heart, he probably thinks that one of the risks of allowing prosecutions of a former president is that someone like Trump will do it, and that we'll then get into the business of taking turns, and whoever used to be president will get criminally prosecuted. And he probably thinks he did the right thing despite the public criticism, because he foreclosed that possibility.
Well, so let's talk about this then very specifically in terms of what it means for Donald Trump. His legal team has already moved to overturn the recent criminal conviction he faced in New York by invoking this ruling. If he
It doesn't apply to this ruling, for what it's worth, because the acts he performed, he was not president, so that's completely inapposite.
Well, actually, some parts of the case occurred while he was in the Oval Office, including the decisions to pay. He was already president when the payments were made to Stormy Daniels to keep her silent. He had been in the office for about a year. So while they may not be able to, overturn the entire case, I imagine there's core parts of evidence that they could have reviewed and then dismissed on appeal that are now, seen in a different light in the wake of this ruling.
That's interesting. I actually had not realized that the payments, I mean, the main set of events that were charged in the case
preceded his presidency. Yes, but the actions to keep it under wraps occurred while he was president. And so I think this could get thorny in that regard. Yeah, but let's putting that case aside, what doors do you think this opens up going forward for Donald Trump should he return to the White House, a ruling like this?
Well, what it means is he's not going to have to spend any time worrying about whether he's violating criminal laws. But to be blunt, he didn't seem to spend any time worrying about that the last time either. I mean, as you just mentioned, he was still making the Stormy Daniels payments when he was in the White House, and he was president when he tried to flip the election, in my view, unlawfully, and when he encouraged people to riot on January 6th, in my view, probably unlawfully. So he can do stuff like that and more so, and feel that he's safe in doing so. I'm sure he finds this whole ruling intuitively appealing. He believed he was above the law to begin with, and now effectively, he largely will be above the law.
In fact, that's the argument his lawyers made on appeal. And I suspect that's the reason the court picked it up, was that core and very clear idea that despite what Justice Roberts has said, Trump, in this court's view, does exist, as any president would in their view, largely above the law. And I think that that's the way this is going to echo through the ages, and in the near term, is going to be startling to people, I think.
Yeah, and I think, look, a lot of it, how this will look in 20 years, this opinion, is going to turn entirely on how our democracy does in the ongoing stress test that it's being subjected to. If we come through the stress test the way it seemed like we had in 2020, having kicked the scoundrel out of office and having upheld an election, even though the leader of the free world tried to flip it, then people will say, okay, well, this was a reasonable holding. We may not think it was the best holding, but it was reasonable because it avoided constant criminal charges against previous presidents. If our democracy continues, and I pray that it doesn't, but if our democracy continues to erode, if Donald Trump is elected and our institutions do not do as good a job as they did last time of holding the line on the erosion of democracy, then people will look at this opinion and they'll say it was a disaster because the criminal law was the final tool available to go after a president who could avoid impeachment, couldn't avoid impeachment, but could avoid conviction of an impeachment because of the political system that we live in with a strong partisan loyalty, and who could avoid most forms of responsibility. And that then they'll see this as a terrible, terrible decision that essentially gave a path to the end of democracy. That's a very grim picture, but I think it's an accurate account of how this case will go in history. If things go that way, people will blame this opinion as a real part of the failure.
We've run out of time, Noah. It always seems to zip by so fast when you educate me and we get a chance to talk about these things with our audience. I want to remind our audience that we are doing these live streams every Tuesday going forward, every Tuesday at 8:30 a.m. And various members of the Bloomberg opinion community will be on board to talk about this election and beyond. So I hope you join us again next week. And Noah, thank you again for giving us your time.
Thanks for having me, Tim. Look forward to seeing you the next time.
So long, everybody.